I received a prospective client inquiry today about a prenuptial agreement. Now, the wedding is going to take place approximately 2 weeks in the future. So the email inquiry was, I'm going to be getting married on this date, which is about 2 weeks away, and my fiance's attorney prepared a prenuptial agreement. I'd like you to review it. So really that's a quick turnaround. Not that we couldn't meet or discuss the prenuptial agreement, but any agreement that really tries to put the hammer down on you with only 2 weeks before the wedding really is a tough document, right? So there is case law that the rule of thumb is that you should have the prenuptial agreement prior to the wedding announcements going out. Is that a good rule of thumb? Yeah, it's an excellent rule of thumb. Right? People sometimes send out a save the date, then they send out invitations. Once the invitations are sent, any agreement on either side, right, husband or wife's, prospective husband or wife, any agreement that they enter into, really they have the pressure and the force of the pending nuptials, right? So this is prenuptial, but really close. It's an almost nuptial. It's really tight. So I'm going to see what the document actually says. It may not say, it may not be that bad. However, think about, and I'm not so worried, well, I'm always concerned, but the person that I'm going to be prospectively the attorney for is being offered the document. I can anticipate that the other side is the one with money and assets that they're looking to protect. But if you are the one that wants to protect your assets, get the prenuptial agreement out soon, at least before the invitations. I was asked to consult on the validity of a prenuptial agreement. So let me give you some of the requirements to make a valid prenuptial agreement, and then I'll go through some of the items that you need to look at to determine whether or not the prenup can be challenged or made void. So in the global picture of a divorce, you have two big issues. Equitable distribution, that's the division of the assets of the marriage, and spousal support, called maintenance. Right? In New York, we call it maintenance. Other states, TV shows, California calls it alimony. New York calls it maintenance. And then you could have children and child support, but those items are going to be governed by the Child Support Standards Act. So the two main things in the divorce are the ED and support, and even future assets. So assets that you had going into the marriage, and then what would happen, you need to address the assets acquired during the marriage, and retirement accounts and things like that. So a prenuptial agreement, to be valid, to be enforceable, has to be in writing. It's not verbal, in writing. It has to be signed by both parties and fully executed in a certain prescribed manner. And that's in the same format as you would notarize a deed. Certain requirements of that. You don't need witnesses, but you need to notarize it like you would a deed. It has to be entered into voluntarily. You need full disclosure. The assets that you have and the value of the assets. So if you have stocks and you say the stocks are worth in Vanguard or Solomon Smith Barney, and they're worth $50,000, but in fact they're worth $500,000, that's not full disclosure. If you say you own property but not stocks, and you own both, it's not full disclosure. So you need full disclosure, and the overall principle is it can't be unconscionable. Unconscionable. Okay? Now, what would make I have notes. What would make a prenup invalid, voidable? Fraudulent information. So you claim that you have a piece of property and you state that it's worth $200,000, and the person believes you or understands that it's worth $200,000, and in fact it's worth $2 million. That's fraudulent information. You can undervalue an asset, right? So that's twin things. You could know that a property or an asset is worth one amount and misinform the other person and tell them that it's worth a lower amount. Say you have a business, and the business, whether it's worth $300,000 or $300 million, the person has to know what they're voluntarily agreeing to waive. This is another item to challenge, to make the prenup void, whether it was signed under duress or coercion. Right? There's case law that informs what that really means. Improperly executed. So let's say you made an agreement and you signed it, but it wasn't signed in front of a notary. That's improper. It could be maybe a contract, or it could be, I don't even want to use that language, it could be perhaps some intention for what the parties wanted to do, but if it was not properly executed, it can be voided. And then if the agreement was unconscionable, so to make it valid, it can't be unconscionable. And if it is unconscionable, then it's a reason to void it. That's it. So fact specific, whether it is coercion, duress, what are the circumstances, was there full disclosure or fraudulent disclosure or undervalued disclosure, and was it properly executed? That's the methodology you would use to make a prenuptial agreement void. So the simulation likes to reuse fact patterns, right? It's code reusage. And today, two different people had similar events. I spoke with a prospective client today where she agreed, she's going through marital discord, and she agreed to permit her husband to borrow from his 401k to buy another property. And in return, he was going to, or did in fact, sign over the deed to the house to her. And that was their own settlement agreement, without attorneys, without a written agreement. And it in fact could have been a fair transaction. Turned out, when you don't use an attorney, you often enough don't have all of the correct documents. So what happened is that the deed was signed. However, some or a few of the other transfer documents were not signed, and this person could not record the deed. And the husband now has second thoughts. So at one point she had tremendous leverage, or maybe not even tremendous leverage, because they arrived at the numbers themselves. But what we have now is, how does she get the gentleman to sign the rest of the documents? Because there's no pending court case. Well, I said, you need someone, in conversation, the suggestion was, you need someone, a friend, a sibling, your oldest adult child, your pastor, a member of your church, a community friend. Someone has to impress upon him that he should honor the benefit of this bargain. And if that fails, or if it's not safe to do, or if it's something that can't be done because you don't have this independent third party or someone with enough gravitas, Well, then you need the court to prompt the gentleman, push him for the benefit of his bargain, and then revisit the entirety of the situation. Perhaps that was not a fair exchange. And in the ode to the simulation, I had a second client today. That was a prospective client, but this was a client that had, in fact, come up with an agreement before hiring me where he was going to sign over the house in exchange for his wife to refinance and pay him off. So in this pre-attorney transaction, he did in fact sign the house over to her. The wife refinanced, and she's holding the money. So now we have to, there are lawyers on both sides, and we have to get to the bottom of it. My associate requested the appraisal. We want to make sure that he is in fact getting a fair transaction, the numbers and what he's going to arrive at. But it's crazy to me that often enough in the same day, I will have the same or nearly similar fact patterns for different people. And I chalk it up to the simulation. Drama on the home front. Siblings fighting over their parent. Siblings disagreeing as to parenting time. The ins and outs of sharing the house that the parent lives in. How do we work through these issues? How do we navigate interpersonal relationships? Well, it's art and science. It's the law. It's an interpretation of the law. It's the human dynamic. And it's not easy. And when there is no consent, there is no agreement, there is no prohibition to visit, what happens? Well, we have to rely on the court. Orders, temporary orders, permanent orders. Something from the court indicating what to do. The human dynamic is that where there is no consent and no agreement, there will be fighting. And I see that across several different disciplines in my practice. In the area of guardianship, we often see siblings fighting over their parent, or a step-parent and an adult child fighting over the care and custody and the money of the alleged incapacitated person. In the divorce and family law context, we see husbands and wives, mothers and fathers, parents fighting over minor children and money. But how do we figure out the path to resolution and to peace? Well, what we do is we try and assess the situation calmly and rationally and find several points of agreement. And when we have the agreement, we build on that. So siblings, parents, all have a love for the person in question. It's the first point. And what would be in the best interest of that person? Would it be to exclude and diminish one parent? Or would it be to have an inclusive, shared environment? So we start there. And then we use that as the bedrock. And once we have one small agreement, we expand it. And once we have that expansion, we expand it further. And it needs to be in writing. Why? Because that's your default position. So visits are on this time, on this day, from this period of time to that period of time, right? 12 to 5 or 7 p.m. till 2 days later, 7 p.m., something like that. That's a minimum amount of time. That's your bedrock, that's your foundation, and then it can always be expanded. And then we build in situations where there's information provided and shared. Maybe the use of an app or a certain designated email to have a free flow of information. So calmly and rationally assess the situation and find even the smallest point of agreement and build from there. Settlement or trial. Oftentimes, parties are so at odds that it's not as simple as, I'm going to use simple numbers, right? $1,000 as compared to $2,000, and let's meet in the middle, $1,500. You know, a good percentage of cases are settled that way. Let's split the difference. Let's meet in the middle. Let's narrow our respective positions. But sometimes, in that same type of example, someone might be at 600 and the other person's at 16,000, and therefore we have no settlement. You can't meet in the middle. You can't, get 8,000 in the middle. It doesn't work. So what do we do in that instance? And you need to conduct a trial, put forth your best evidence, and let the judge decide. That's a frustrating and time-consuming position, but it is often necessary.